Good evening, everyone. This is Commissioner Brenda Harbin Forte. This is the CPRA Policies Ad Hoc Committee meeting. It's about 10 after 6. We'll get started. We have Commissioner Angela Jackson Castaigne, Commissioner Kareli Ordaz. We have interim CPRA Executive Director Charlotte Jones. We have her staff members, Emma Deal and Mika Bell. We have member Mariano Contreras, a community member. And are you all seeing anybody else on yet?
Nope, that's it so far.
I'm sorry?
That's it so far. Thank you.
Okay, all right, great. Welcome, everyone, and thank you. And even though the month is almost half gone, Happy New Year to everybody. We're gonna go forward with going through the draft policy, and we will just pick up where we left off last time, and we had gotten to section D, which is on page, if somebody can get me that page there, page 29 on section D. And this is on investigation timeline and review. And we're just going to start going through. It doesn't appear that anyone had any comments on that section. And we've got another person joining us. So are there any questions or comments or anything? I think this part was pretty clear. We got the so if there is nothing on G,
maybe, sorry, Commissioner, it might be helpful if we just because the timeline I know is very important to folks. And I hate to put you on the spot, Charlotte, but maybe if you give just like a brief overview of what the timeline is for all of the cases or the complaints that have been filed from the 150 days until.
Okay, Charlotte. Yeah, I think you gave us that. I think you have a slide or gave us a slide presentation last time. Can you pull that back up, you or Mika?
The presentation that I gave last time.
It shows that. Is that what you mean?
I got into the timeline of it, so I can tell you orally what that is. It was more about the process as opposed to the timeline. So the investigators have a goal of completing the cases within 180 days or by 180 days per the charter. It's a stated goal that we try to work towards, but the charter mandates that we complete the cases in 250 days. In addition to that, there's a law that indicates that officers have to be disciplined before a year from the time the complaint is filed, or the complainant should have been known, or the department should have been made aware of the complaint. And so that's the year time frame. So most of our timelines in the SOP is based on our charter mandate of the 250 days. And so, Mika, if you could scroll up a little bit. What we indicate is, down. It's down for me, I'm sorry. What we indicate is that we want communication in that interval time. So we have a time indicated at 90 days that the investigator should communicate with the supervisor to update on, what's going on with the investigation, if there's any issues. Could it possibly be completed by the 180 days? Scroll down a little bit for me, Mika.
Okay, can we hold on a moment? Reggie says he's having trouble getting in, so I just forwarded him my login.
I'm in now. Thank you.
Oh, you are? Okay, very good. Thanks now. Okay, great. Okay, so Reggie Lyles is here as well. Okay, I'm sorry. Go ahead, Charlotte.
Oh, that's okay.
Sure.
Just gonna look at it on mine because it's easier. Okay, so what I've indicated in the SOP is that on or about the 90 days, we want to have a meeting with the supervisor and the investigator to, address any issues, or if the supervisor needs to provide any additional assistance at that time. If the case is still open, we would like the CI2, the investigator, to send an update letter or email to the complainant, letting them know that the case is still open and still being investigated, what I consider to be like a midpoint kind of notification. So then the next section indicates that on or about the 150-day interval, keeping in mind that our mandate is 250 days, the CI2, the investigator, will make every effort, obviously, to complete a draft investigation of the report, and to the supervisor for any edits as needed. So the timeline goes into notifications to the complainants. Trying to move this down. Updates at certain intervals. You have one at notifying the supervisor at 180 days or just prior to 180 days if they don't think that they'll be able to complete it. Addressing any comments or edits within 5 business days. That's included in the timeline. Approximately 30 days before the 250 due date, that they also have a meeting and notify the supervisor of any issues or problems that might stop them from reaching the mandated 250 days. Again, addressing the 3304, which is the 1-year requirement, making every effort, of course, to complete it by that time. Notifying the supervisor at least a month before if there's any issues that might stop them from getting it completed. So those are the basic timeline parameters: 90 days, 150 days, 220 days, and then 1 month before the 1 year for notifications for communications between the supervisor and the investigator, and notifications to the complainants.
Okay, we have a couple of questions. Also, I see Pastor Thompson has joined us as well. Mariano, your hand was up first, and then I'll go to Commissioner Jackson Castaigne.
Okay, thank you. Ms. Jones, in terms of the 1-year deadline for discipline, is there any exceptions to that? Can the director extend that, or is there any exceptions at all?
There might be exceptions, but I don't believe that the director would have that authority to do that. I believe that it is a state law, and Emma can probably speak better to that for me, but it's a state law, and so I wouldn't have any authority to override that.
So Charlotte is accurate. There are not circumstances where the CPRA or the police commission could make a determination that that 1-year deadline should be extended. It's similar to a legal statute of limitations in a criminal case or a civil case. There are some exceptions provided by the law that creates that deadline. So for example, if the officer's conduct that's being investigated is also the subject of a criminal investigation or a DA prosecution, the circumstances can be told until that is over, so that the two essentially don't interfere with each other. There are a handful of exceptions like that, but for the most part, and in almost all cases, it's a strict 1-year deadline.
In your opinion, is that enough? I mean, is that sufficient to move forward, or just in your opinion?
Yeah, so in my experience, it is enough time for most of the cases that I've worked, taking into consideration where there is a criminal investigation or something like that that slows it down. That obviously in those cases, sometimes we're not able to really jump into the investigation until that criminal investigation's done. But in general, I would say it's enough time. I think with the CPRA's current staffing, it is not. But when we are better staffed than we are at the moment, and we have a caseload more similar to the caseloads that I've had prior to the last couple of years, it is enough time to conduct investigations, even in cases where there sometimes are 20 or 30 subject officers. It just, that one case becomes sort of your focus for a while.
Thank you.
Mm-hmm.
Okay, thank you. Commissioner Jackson Castaigne, do you have a question?
Yes, Ms. Jones, do you think it would be beneficial at all, or if not in this section, maybe somewhere else, to add some pulse checks with the complainant so that there's some visibility in terms of like when the complainant expects to hear the progress of their case.
I'm sorry, Commissioner, repeat the first part that you said somewhere. We could put here that,
Would it be beneficial to add something to say check in with the complainant so that they understand where their complaint is in progress, or are they just to assume that they wait, the 250 days or whatever it may be?
no, that's what it indicates in section 2, section 2A, I'm sorry, D2A, that the investigator will send an update letter at the 90-day interval.
Perfect. Thank you. That was my subsequent question, which was that listed someplace else in the timeline?
Yep.
Thank you.
Okay, great. Any other questions about the investigation timeline and review? Okay. Let's then go on to the next section. And by the way, can you go back up a little bit, please, for that footnote number 10? I think my note was that should go into the text, whatever's in footnote 10.
Yes.
Yeah, so I think it should be put into the text rather than a footnote. Okay. Okay. And E is investigation findings and notifications and discipline. Do we have, and I did not make any changes in that one, I guess. Charlotte, do you, can you or your staff run kind of through what all of this says?
Sure. Basically, it's indicating that the director is responsible, or their designee is responsible to make notifications regarding the findings and proposed discipline to the chief of police and the commission. If the investigation is a level 1 use of force, according to the charter, sexual misconduct or truthfulness allegation, the director will issue the written findings within 48 hours of the completion of the investigation. If other kinds of police misconduct, the findings and proposed discipline are due within 30 days of the completion of the investigation. As you know, the chief has to, or their designee has to agree with CPRA's findings and proposed discipline, both, and they shall notify the director, who will notify the chair of the commission of that the findings are agreed upon. If there is agreement, the director will notify the supervisor and the investigator so that a letter can be sent to the complainant indicating what the findings are. We have a template that I'm going to create to include in with the SOP of what that general letter looks like. We can't be too specific about the investigation, their protections that the officers have. So basically just advising them of the findings for their allegations. If there is no sustained findings and no discipline, and so there's no Skelly hearing that's been triggered, we just document the database and close it out. If there is discipline that gives rise to the right to a Skelly hearing, the supervisor will not close out the case until they receive direction from the director and the Skelly hearing process is completed. If the chief of police disagrees with CPRA's findings and or proposed discipline, they will notify the director of his or own findings and or proposed discipline. Sorry. So there's a concurrence process, and if there's continued disagreement and no concurrence between the director and the chief, it goes to a discipline committee formed by the commission. The discipline committee, has the final decision on the findings and or discipline, that should be issued. And they notify the director who will proceed based on what that decision is, whether it's closed or not. That's basically the notification process.
I recall recently with respect to a discipline committee, there was some confusion about what the discipline committee should receive from CPRA. Do you remember that? I think that Aaron wanted to hold back some things that I think some of us thought the discipline committee should have.
I'm
I'll
not
have to-
aware of what he tried to hold back. I believe that they're entitled to everything that we would have used to make our decision.
Right. I will try to find, I think there might have been an email exchange or something. I think that discipline committee ended up not having to go forward after all because there was a resolution, but there was an issue with respect to whether or not certain things, some of the analysis or something, CPRA's analysis or something, whether that should go to the discipline committee or whether the discipline committee should form its own conclusions about what the evidence showed or something. I'll figure it out, but we should footnote that, put a pin in that part of it so that we can clarify what is supposed to, what exactly what CPRA should turn over to the discipline committee. Mariano?
Yes, I believe somewhere in this document, it states that all findings and all reports from CPRA should go to the chair, the police commission chair, as well as the chief. So doesn't that supersede, so holding back anything to the discipline committee should, it should be in the chair's hands.
Right. And we will, yeah, exactly. I mean, I think that was our view. But I'm not, I can't remember Aaron's rationale for wanting to hold something back.
Okay.
But we'll figure it out and we'll make it clear what should be turned over and what should not.
I haven't seen anything in the charter that indicates certain things should be held back. He may have been aware of something that I'm not aware of at the time, but I haven't seen anything yet. So I haven't included anything like that in the SOP.
Okay, yes, good. And we need to, we'll make sure that we spell out exactly what goes to the discipline committee so there's not any confusion in the future. And I'll try to see if, I don't know if the chair was involved in that discussion. I think the chair was going to be on the discipline committee. It might have just been those of us who were considering, who were being considered for membership on the discipline committee. But we'll get it squared away. Just make sure that we
I do
all
have at
that
number 7. Right. I do have at number 7 that evidence will be submitted in accordance with the language of the charter, which is 604G2. So it indicates what should be submitted in that.
Okay. Great, thanks. Any other questions or comments on this section? Okay. Next section, part 3, is on training. I am not sure who added that language there. Charlotte, that it's from you. The language that changes, that's from you, Mariano.
Yes, that was, it just seems that, there might be too much of distance between the CPRA, the agency of the commission, and the commission itself. And I thought, that it would be, and maybe everyone here can help me out. I just thought it'd be a good idea to have CPRA staff attend, let's see, what did I put down here? 3 commission meetings, 1 or 2 commission meetings per year, just to see what takes place, boots on the ground, so to speak, so that there's not that big disconnect.
Any other thoughts on that topic before I go to Commissioner Jackson-Castaigne? Charlotte, what about you? Your in-house folks?
No, I think
one or two?
that's a good idea.
All right.
I think that's a good idea.
Yeah. So is it a minimum of 3? Is it a minimum of 2?
I don't know what I was thinking at the time, but 3 commission meetings, that's a lot of commission meetings, given the amount of work that you folks are doing already. So I don't know what I was thinking, but, maybe a minimum one meeting, and then who knows, maybe Ms. Dill would get the bug and she might want to attend more. So, but a minimum 1.
Yeah, I think a minimum of 1, and then Charlotte or whoever ends up being the final executive director can certainly direct staff to attend more if they think it would be appropriate. Commissioner Jackson-Castaigne?
Yes, Mr. Mariano, I think that is an excellent suggestion, and I really do appreciate that. I think it's really important that we're all involved in one another's work, and so that it helps to prevent or circumvent any silos and also break down any ones that currently exist. So I love that recommendation. My question was probably more so for Ms. Jones. In reading the remainder of this document, I felt that training and conflicts of interest and confidentiality agreements would probably best and this is just my suggestion, would be more suited for a broader orientation or onboarding document rather than SOPs, and that this one just focuses on the procedure of going through a complaint or an investigation from start to end. So I appreciate all of this information. I think it is fabulous and we don't need to lose it. I think we need it. And I also think that, while we have the audience that we do have, that we should definitely incorporate their suggestions. But I do think it belongs probably in a separate document as part of a broader onboarding or orientation materials. And I'm happy to hear any other thoughts that may differ as well.
I agree. I agree. We should probably have a training manual or something separate outside of the procedures. But Charlotte, Emma, Mika, what were your thoughts in terms of having it as maybe a separate document or rather than in the rules of procedure? It doesn't really go to procedural things, right? The training.
Right, I understand, but the only reason I think that it would be a part or should be a part of the SOP is because it's really going to be a requirement for the investigators. It's not like just something that they do. Of course, they do have onboarding and they have this information, but because we're going to hold them to this certain requirement, that's the reason that I think the training should be included in the standard operating procedures, so that everyone knows what they're required to do, even though it doesn't go into the specifics of what the trainings are, knowing that they're required to have these kinds of trainings.
So I think this goes back to maybe the purpose of this document, and if it is the standard for doing this job versus the standard or the procedural aspect of working an investigation from its inception to its closure. So maybe we might need to go back to the beginning. And I know we talked about also revisiting the executive summary and everything anyway, but what is the breadth of the document? And if it's simply to explain the process from procedure from the beginning of an investigation to the end, then I think we should probably remove this and put it elsewhere and part of their onboarding. If it's like, this is how you do your job more generally, then I absolutely agree with you in terms of leaving it in here.
You're absolutely right. It is a procedural manual. So we're clear about that. It's really how you do your job. And so from that standpoint, I mean, I'm not opposed to it being a separate document, just the reason that I included it, because it's more than just for the onboarding of the investigators. That's a continuing process with the training.
Right.
So
If I can add something, I do think that the Commissioner, because you mentioned a couple different sections, I think that the conflicts of interest section and the confidentiality section in particular seem like something that we would want to keep in this document, because they really are foundational to the duties of an investigator and the duties of an intake technician. And so I think it's helpful to have them documented someplace like this that's really sort of handed to employees on the first day as a foundational document for the agency. The training, I think, I'll defer to Charlotte on, but I think it's a little less critical to be included in here, mostly because it's actually relatively difficult to find external trainings for oversight outside of a couple specific opportunities that become available every year. Most of the trainings that we receive are through one or two agencies outside of Oakland who provide oversight training, or our internal trainings that we receive either from supervisors within the agency or from the agency's attorney. And so in my mind, it's unlikely that investigation staff would be seeking out training opportunities on their own in most circumstances. They would mostly either be attending mandated trainings or trainings that were suggested to them by the director. And so I think if we wanted to set a specific number of hours of training that's expected in the field every year, that makes sense to me. But I think the individual sort of topics is a little bit harder to hold the individual employees to finding on their own. And so that I think could be in a separate document if we felt that was the better way to handle it.
Do you have conflicts of interest or confidentiality documented elsewhere in your materials for new investigators? Like, I'm sure there's like a confidentiality agreement that people have to sign, et cetera.
At this point, we don't have any sort of standardized policy and procedure documents. We have a number of sort of individual, what I would call like a policy or procedure declaration when a particular issue comes up and a policy or procedure is set. And so staff, at least all of the investigation staff I know, are aware that we should declare any conflicts of interest and notify the director. Everyone knows that confidentiality is part of the job because it's part of the job description. But there aren't specific forms that we have created at this time for those two issues.
Okay, thank you. I appreciate it. So given that information, Ms. Dill, I think it's important that all of these things are documented, and if they're not documented elsewhere, then maybe in the interim, we keep them here so that every new investigator is aware of them. And then as we develop more robust onboarding policies and procedures, we might want to decide to shift them elsewhere. But thank you for entertaining my suggestion.
So we're agreed that this stays in.
we agreed for now, it stays in.
For now, until we find a more suitable place for it.
Okay, okay. And Reggie Lyles, Reggie, your hand is up.
Yes, I'm for having it stay right where it is. And I think it's important because it speaks to our expectation of the investigators and that they have to be contemporary and they have to understand, because things shift, politics shifts in relationship between the police department and the community shifts. And if you are at least attending one meeting a year, I surely don't think you need to do 3, but I was comfortable with 2, one every 6 months, that every investigator is expected to have their pulse on the lament of the community. You have to know what the community is saying. Now, if we say, oh, we put in another document, and you don't even discuss what document, or that you even list the names of that document in this document. So how would someone even know that the expectations of the investigators, that you should know that there's been a rash of police shootings just in this area? You should know that the complaints in Ghost Town with the writers were happening for years before the police even looked into it. So investigators are not or shouldn't just be in a silo. I'm only concerned about this investigation in front of me. You should know the temperature of the community, or at least somewhat. You're not isolated. You have to be a part if you're going to investigate and keep law enforcement adhering to their obligations and what they swore to uphold. So I think we ought to keep it in here. I'm a little chagrined why a little thing like this has to be, oh, we got to put in something else. Why? What do you mean? Keep it right where it is. So when people read it, they'll know, look, we have to understand what's going on in this community. And Oakland is a multi-layered community. So what's happening in Deep East Oakland may not be happening in Fruitvale, may be different than in North Oakland, may be different in Deep West Oakland. And fortunately, we want people who can hear the lament of the people. I'll end there.
Reverend Lyles, if I'm understanding you correctly, are you talking about the comment about the investigators attending the commission meeting, or are you talking about the training? Sir? Okay. I think he's talking about the commission meeting, the investigators attending the commission meeting, whether we should remove that or not. But in either case, we're leaving them both in, so.
I think it's
I'm
probably,
on mute. I'm on mute. That's why. That's why nobody's responding. Can we
Okay.
go back up to section 3 where it says training?
I think it's the totality of all of the
See,
items that
no,
he
no.
might have
Oh,
been
I'm sorry.
referring to.
Well, let me make my point. My point is that under training, the first entry is that they attend minimum, right now it says 3 commission meetings. So it's all tied in together with the training and attendance at commission meetings. I thought someone was drawing a distinction between training and attendance at commission meetings. So, and I'm sorry, Charlotte, I missed your point, and then we'll come back to
I was
commission.
trying to get clear. That was my fault. I was trying to get clarification of which thing he was talking about we should leave in or not leave in. That's all.
I think he's saying leave this whole section on training in this document and not try to put it someplace else, not try to put it in a separate document somewhere.
A separate unknown document.
Yeah, a separate.
we don't even know,
Yet
so-
to be.
So that's how things get lost, right?
Yeah.
That's how expectations get lowered. So
put the training and the conflicts of, leave the training section in part
yes,
3.
I want the investigators to read all of this.
Yeah, and part 4, the conflicts of interest as well. Leave that in.
Yes.
I would just add that maybe for the conflicts of interest part, for the CI2s, they are required to complete the Form 700. So maybe we just add that in this section, just as part of the conflicts of interest, that they make sure that they file that annually. I think it's annual.
Yeah.
Yeah, that's
Yes.
right, Mika, upon hiring and then annually after that is right. And I think we can just generally reference the city's conflicts code, and ethics code also has specific rules that apply to all CPRA employees regarding the acceptance of gifts and that type of thing.
Yeah.
Yes. Commissioner Jackson Chastain?
Yes, thank you. I do want to recognize Mr. Lyle's comments, and I do think these things are important. I just think that they belong separately from the process to investigate or to conduct an investigation from beginning to end. And they all, including this procedural process, need to be part of a broader manual. And it could be, whatever you call it, it can be like, this is how you do your job manual. And it's a whole booklet, and it says, this is your training section, this is your conflict of interest. Here are the forms that you sign. Here is how you conduct or work an investigation from start to finish. I think it is, as he mentioned as well, important to reference other materials that are important or relevant to this procedure. So if there are police, stats or data that they post continuously on their website, then it's great to have a link there so that the investigators know, or IAD link or whatever it may be. But I do think that this should be probably, like, in the future when we do have a broader set, this should be one piece of a larger body of work that really does describe what CPRA does from start to finish. And in that light, then, like right now, I understand we don't have that. So like, we will work with what is good to suffice. But in the future, I think if the scope of this document is focused on procedure, then that should be the scope, and that's it.
Okay.
Thank you.
Okay. Mariano?
Yes. So in the beginning, I mentioned, and I think we included it, that the commission hires the director, and that director of CPRA should reflect the complainants, the ones that file the complaints. And I think we agreed on that. And so on this training section here, we're talking about training requirements, but of who, and we mentioned the investigators and the different levels, but we're not really talking about, who do we hire, who do we recruit, what kind of pipeline do we want to set up? And if this isn't part of this, the purview of this document, then I'll step aside. But if it is, I certainly would like to have some kind of say in that. Thank you.
Sort of like a policy statement or something, or commitment to equity and inclusion and diversity or something like that.
Yes.
The hiring of you mean for the hiring of the executive director?
No, not the director, the
hiring of the investigators.
The investigators and the staff. Ms. Jones, is this not the purview of someone? Tell me if it's not, then I'll step aside.
Typically, this would come for the staff that's already hired. They would be the ones who would have access to this, so it wouldn't necessarily be something that we would include in the standard operating procedures on how they were hired. That would be separate, obviously. Some considerations that we would need to make, but not part of, I wouldn't think, the standard operating procedures. This is for the staff that's already been hired.
Okay. Then let me ask a question, and maybe this is to Judge Brenda Harvin-Forte and the other commissioners. So where would something like that be discussed or brought up?
And I think, does CPRA have a mission statement? Or I think part of it we put in here, what the mission is. So it could be part of this document. Although lines are getting blurred.
Let me just say, when we do post for the positions, if I could answer, We have that information about diversity and equity and inclusion, that language that's been reviewed by the race and equity team, as well as the city's race and equity department. So those are considerations that are made on the HR end when we're posting for positions.
Okay,
Thank you.
okay. Commissioner Jackson Chastain, did you have a comment?
I think I hit that on accident, but I of course do have a comment either way. So I think Mariano's comment is perfectly appropriate, and I think we do need to identify a place where some of these broader topics can be addressed. And so maybe that lends itself to us revisiting the beginning of this document and understanding what the scope of it really is. So I think it's great to have the contextual history and the mission, jurisdiction, and like code of conduct and all those things, just to give context to any document that we develop. But if it is focused purely on the investigation processes from start to finish, then it is probably not appropriate to have some of the comments that Mariano's mentioned. I think it is essential that we do have it as part of a broader body of material. But I think we need to better define what this document actually is. And then there might be some other things that we want to shift to something more broad as well. And again, you know, like keeping in mind that the target audience of this is not necessarily the public, although it is a public document. It is to teach investigators like the step-by-step process, my understanding at least, and correct me if I'm wrong, the step-by-step process of how to conduct an investigation. And in light of that, I think that like maybe even the top few sections could be part of something else. And that this is just one piece of something broader, and we might need to think about developing that as well.
Charlotte, any initial thoughts or anything from you?
I definitely don't have an issue including the top halves in a separate document, but I do think that they need to be a part of the SOP as well. That doesn't have to be exclusive. You can have these, you know, topics at the SOP and a separate broader document as well. So
Yeah, I
Okay,
think those are important things to be duplicative about, so.
okay. We can kind of talk about next step. We've gotten through the document. There are some suggested changes. There are a couple, we put a pin and a couple of things. One from a couple of meetings ago, we put a pin in something. And then tonight, we put a pin in something to make sure that and somebody should help me and make a note of it, to make sure that it's clear what CPRA must turn over to the discipline committee, and so that we can avoid any confusion in the future about what happened. I'll find I'll try to get more history to see. It may be a non-issue now. I hope it is a non-issue now, but we will we'll clear that up. Perhaps what we should now do in terms of next steps for our project is to try to get another draft with, it's still going to need to be redlined, but I think maybe we get another redline draft, a clean copy and redline copy, and go through. There are some things that still need to be done. I think we were going to reorder the glossary of terms, for example. That still needs to be done. We were going to put some schematics in, right? Like some flow chart, at least one flow chart or something. We were going to put in as well, like an org chart that sort of shows the interrelationship between the police commission and then the three agencies that the agencies that we supervise, the three OPD, CPRA, and the IG. I think we were going to put something like that the IG and the IG's proposed, in the IG's proposed policies and procedures. I know that she had sort of like an org chart type of thing. It might not have been the most accurate, but and that the lines of authority might be a little bit blurred, but we should try to have something like that in
Okay.
this. I think we're great. We do that. I'm sorry.
I was going to say, I'm sorry. I think I did upload something like that in this shared folder, but I'll include it as part of the document as.
Yeah. Yeah. What I think we should do now is start pulling this document together and trying to figure out what's going to be in this document. And then also sort of your flow chart about the schematic of the investigation itself. That should be, we need to figure out what page that's going to be on. And again, we talked about rearranging, reorganizing the glossary of terms. And so we need to sort of try to get those things done, I'm thinking, for perhaps our next meeting. So we can try to get a better picture of what this document is going to look like.
Well, I would like the opportunity to, in addition to those suggestions, the ones that are on the comments on the side, I do know that other suggestions were made during the meetings. And so I'm going to have to go back and review all of the recordings so that I'm capturing everyone's concerns and trying to appropriately address
Sure.
them. And hopefully
Sure.
I can do that by the next meeting, but I want to have ample time to really do that thoroughly. So
Yes, of course. Of course. Anything else?
I can give something.
I'm sorry.
I was going to say by the next meeting, I can try to give some clean copies so that we're able to work with it better. But I want to make sure again, that I incorporate everything. So
Okay.
I don't know if I can have that fully done by the next meeting.
Okay, Mariano.
Yeah, I just, thank you. I just wanted to ask Ms. Jones, I mean, this is your agency, you're the acting director and possibly the director. Is this sufficient? What do you think is missing, or, tell us now.
Well, let me just say, I'm really glad for this ad hoc. When I prepared it, it was just kind of me basing everything on my past experience, on things that I thought should be there and the things that I thought needed to be addressed over the years. So from my own perspective, I didn't know what was missing, which is why this is so helpful to get the input from all of you on the things that I may have left out and that needed to be changed. So for me, I think that this is a really good experience for adding things. Like I said, I'm going to go and read all of the comments, all of the edits, all of the conversation that we had about the things that should be changed. And I think it will be even more comprehensive then. So I think maybe at the end, we'll all maybe know what's missing. But for right now, I think we're at a good place.
Okay, very good. Now, our next meeting would otherwise be, it would be 2 weeks from now. Let me show it. Anyway, it'll be Tuesday after next. So perhaps maybe we should try to maybe sort of be ready to review maybe even the first half of the document or something, or up through section something C maybe.
I'll definitely shoot for that as much as I can, starting at the top, and then I'll let you know what hasn't been corrected or changed or edited yet.
Okay, and then we can keep on our every other week schedule. And we are doing, this is a big project. So we've done well, and I want to thank everybody for their input and their hard work, and particularly Charlotte, you and your staff for everything. So we are getting there. It's going to be, there's still some details, but we're doing quite well. So let's unless there's something else we need to discuss tonight, there's no need at 7 o'clock. There's no need of going until 7:30 unless we have something else that we need to talk about or to deal with and make some decisions on. Anything else? Otherwise, we can let everybody go to start working on the updates. And again, Charlotte, you can, if you're done with half of it and everything or whatever, we'll go from there.
Okay,
You guys have you got a lot on your plate and you're short-staffed and everything as well. So you do the best you can.
I definitely will.
Yeah. And do you need to meet even with labor or anything about attendance at commission meetings or anything? Or how will that impact your budget? It's going to be overtime for your investigators, right? If they have to.
I don't think that I need to contact labor necessarily. I can't require them to work overtime, and I wouldn't attempt to do that. It would definitely be something where they would adjust their schedule, and I would give them options, which meetings to choose, or, which days they want to go. So I would definitely have a conversation with them about that and leave a lot of that decision up to them.
Okay, then. All right.
Pay
Okay.
him twice as much as Brenda Harbin Forte.
What'd you say, Mariana?
Pay him twice as much as they pay you.
Yeah, that's right. Yeah. Hey, they ought to be paid three times. Three times as
No,
much.
for sure.
They pay me, 0 times 5 is still 0, right? Times
Right,
3
right.
is still 0, right? So, okay. Anything else? Anything for good of the order? If not, why don't we call it an evening, and I'll see you in 2 weeks. Thank you all very, very much.
Happy New Year, everyone.
Thank you.
Happy
Yes.
Indeed.
Bye.
Okay. Bye bye.
Have a good
you.
evening.
Good night.
Bye bye. Take care, Pastor Thompson and everybody. See you all.
Bye-bye.
Bye bye.